Today on the podcast, we're going to be talking about estate planning. Now, this topic can sometimes invoke some interesting reactions and can mean a lot of different things to different people. In fact, it's one of the questions that I often ask clients when they first hear it. When you hear the words estate planning, what comes to mind? So, my question to you, listener, is what also comes to mind for you? Maybe it's an experience that you had with a relative, a friend, or a family member. Reading about a lack of an estate plan from a famous celebrity in a news article. Or maybe right now it's you dealing with the estate of your departed spouse, your lost loved one. Wherever you're at, today's podcast is intended to help you learn some of the basics of estate planning. Now, I am approaching this from the standpoint of a financial planner. So I'm not an attorney, and everything we're going to talk about today is not legal advice, either in general or specific to your situation. Instead, the goal of this is education to help you be empowered about some of the terminology, some of the decisions that might make sense for you to do and apply in your situation. Ultimately, the way I love to define estate planning is about protecting your loved ones and honoring your wishes, both now while you're alive and at some point in the future after you're dead. An estate plan is composed of several components, typically related to two primary areas: giving, so the legacy piece, who are the people that will get the various assets, how those assets will be given or distributed. And then the other side, besides give, is protect, protecting yourself now. So, who will be the key people who make decisions, healthcare decisions for you if you cannot make them for yourself? Who will make final decisions for you financially, both now as a financial power of attorney, say if you could not speak for yourself, or in the future as the executor or perhaps even the trustee of your trust. Related to that also, if you have minor children, who will care for those children, who you're appointing as guardianship, take over that role of parenting on a legal basis. Now, there's questions that often come up like, well, who needs a estate plan, or why might you need an estate plan? Typically, for most clients and most people, the situation first comes down to this idea of control, helping to allow the right people in the right situations to step in and make the right decisions for you. I often tell people that everyone has an estate plan. It's just whether yours was created by you or governed by the laws of the state in which you live. So if you don't have a written will, for instance, well, your estate will be governed by typically the default provisions of your state. Often that may mean people or procedures that you would not wish, that would not come with that. For other people, it comes down to control about having the right people in the right place to make the important decisions related to privacy. When you die, your will go through probates. Your assets can become public record. Good estate plan can help these things flow properly, in many cases entirely privately. And lastly, probably the most important one that I hear pretty regularly is the idea of peace of mind. I rate clients when they first come on board on a scale of 1 to 5, how confident are you in various areas of your financial life. And inevitably, estate plan is often one of the lowest, if not the lowest, typically 1 out of 5, maybe 2 out of 5 in confidence, even for clients who already have an estate plan done. Now, some of this comes down to the fact of the language can be convoluted, lawyery, legalese, right? We use those terminologies sometimes. Oftentimes, maybe they met with an attorney, but things weren't explained well to them, or not sure how it all integrates together. So the goal of this and every conversation I have with people around estate planning is about knowledge empowerment. So you can understand, so you can have that confidence, that peace of mind to make sure that you and your loved ones and your estate plan align with what's important to you. Your wishes dictate it. Estate planning can also help protect things like adult children in the case of an accident. So oftentimes our clients who've got kids, say, off at college, this could be a place where without a medical power of attorney or a HIPAA release, oftentimes you as the parent would not be able to get medical information and step in. So helping to make sure that's done ahead of time, and then ultimately helping everything work together. Estate planning can be that hard topic though, right? Planning for what we hope will never happen, planning for what will eventually happen, and planning for what we want to happen. Learning how to sit in that hard space, particularly when you're on your own grief journey, can be a challenge. However, I can tell you, having done this dozens and dozens and dozens of times with clients on their own grief journey, many, many widows in similar positions as you, having your own estate plan done can help alleviate other parts of your life anxiety. When you can focus on things that you can control, it makes sometimes the uncontrollable aspects of your life just a little bit easier. So we talked about the big picture aspects of the estate plan. So let's walk through some of that in more detail. Let's talk about the 5 major decisions that go into the estate plan. I referenced these earlier, but if we go in a little bit more detail, we can see the beneficiaries. Now, generally for most people, this is the who of what will receive it. So if you have children, typically most clients start there for distribution, oftentimes in equal shares. However, there's also opportunities to leave other family members, friends even, as well as specific gifts to charity, sometimes a specific dollar amount in those cases, or a percentage of your estate. This is where it can sometimes be helpful to think about, well, how much would those important people, such as your children, need before they start going beyond that to other circles? Look at the amount of financial assets that you already have and determine, okay, well, your children would be sufficiently covered with, say, $1 million in assets. Maybe your estate has 1.5. So that gives opportunities to give above and beyond that to other things like other people and causes that are important to you. If you're not sure what that figure could be, that'd be a great opportunity to engage with a financial professional, financial planner who would help you look at that. Second is the method of distribution. So this is how the beneficiaries will get everything when you were to pass away. Now, depending upon their age and financial capabilities of the beneficiaries, it may not make sense for them to get everything right away, particularly when we're talking about minor children. So again, if you've got kids under the age of 18 with these young beneficiaries, if you do not have age restrictions built into your estate plan, typically based on the laws of the succession rising to adulthood in each state, your children may have full control of all their assets as soon as they turn age 18. So maybe they were in their teenage years or younger than that. Somebody else would take care of the money until they reach that age. And then suddenly at age 18, all that money is theirs to do whatever they want with. I don't know about you, but I remember what I was like at age 18. I know what most people are like at age 18. Brain research also shows about brain development at that age. Not always the most wise to have several hundred thousand or maybe millions of dollars given complete unlimited access and freedom to. So for many example with young beneficiaries, we see clients put in restrictions into their estate planning documents, specifically into the instructions in a trust, such that there be age-based triggers, life-based triggers, such as providing for education, money for a first car, house down payment, wedding, career involvement, and then additional assets distributed beyond that. You remember, though, that even if they don't have access to the principal, the funds in there, they always have access to funds from the trustee for healthcare, education, maintenance, and support. So they're not going to, be destitute if they don't get it. This is also important if you have a beneficiary that has special health needs or other special planning needs, to get involved with a estate planning attorney who has expertise in that. That is definitely beyond the scope of what, for example, we do with clients. That's where we bring in the professionals. Successor, trustee, executor, or financial power of attorney. So this is the person, or sometimes people, if you have the role split up, who will make final decisions for you in the financial world if you cannot. So imagine, our typical soap opera scenario where you're in a coma, can't speak for yourself, but your electric bill still needs to get paid. This would be the financial power of attorney who would step in, get access to your bank account, make sure bills are still paid in time. Upon your death, now this person that you've named would step into the role of executor. This person will follow the terms of your will to legally carry them out. Similarly, a successor trustee, this is the person that would be in charge of all the funds that you put into the trust or poured into the trust, oftentimes caring for those minor beneficiaries. Some clients may name the same person who is the guardian, who is caring for the children. They're living in that home. Might make the same person as the trustee, but not always, particularly when you think about the person who makes a good trustee as someone who is financially responsible, who would have a similar financial outlook and view on the world as you, and is generally a good decision maker. Sometimes clients will run into a scenario where they don't have a family member or a close friend or someone in their life that would fit the bill, in which case a professional trustee, this is a trust company, that could step in and fulfill this role. Generally, most clients are going to want to name several successors in order of precedence. In other words, if option one couldn't serve for whatever reason or had to resign, a secondary person or even a tertiary person could step up in that role. Healthcare power of attorney. So this is the next decision. This is the person or potentially people who would make healthcare decisions in the event that you could not. So again, back to the soap opera coma. Now you're needing a procedure done. Who would step up? Who would be the person that you've named? You could say, yes, do this procedure. Generally, you want somebody here that is able to have emotional stability, especially during some of the difficult medical decisions that might be made. And you also have the ability to state your end of life and other restrictions as a part of this healthcare decision through a living will or a healthcare directive. So, a healthcare power of attorney says this person can help make decisions when I cannot. A healthcare directive or living will says these are the things I want done. These are the things I do not want done. Everything from pain relief and life support to do not resuscitate all the way up to specific kinds of medical interventions. Lastly, I referenced this earlier, but if you have minor children, this is the guardian, that the people who would have the legal custody of any minor children. Again, with widows in this situation, it becomes even more important to name a person here when you are now suddenly the solo parent, as opposed to having a spouse ready to step in at that point in time. We often see people name close family members, parents, siblings, but dear friends can also count in this role. We also see other children that you have over the age of 18 who could legally step in as the legal adult. And again, most clients here would want to consider naming 2 to 3 successors named in order of preference. Of all the challenges and conflict that we typically see, this is often one of the hardest ones to make because it's such a deeply personal decision. This is where sometimes clients will come alongside, in addition to the legal directives spelled out in the will, the trust, and other documents. They may have what's called a letter of intent. This is a non-legally binding but still helpful resource that may come alongside and give guidance. For example, about things related to what they would want their kids to be able to grow up doing or not doing. Unlike the will or the trust that are legally binding, they shall do those things that you've instructed there. This is more prescriptive in guidance to help them know what your wishes are. Some clients who find that difficult to even write it down may find it easy just to do a video recording or an audio recording to talk through it rather than try to put it in black and white on paper. Okay, having covered those 5 major decisions, let's go into some of the basic estate planning checklist. Let's start with the idea of inventorying your things, your belongings, your stuff. Now, you may think that you don't have enough to justify estate planning, but remember, estate planning is about more than just your physical belongings. This is just one piece. However, once you start looking around, you may be surprised at all the tangible and intangible assets that you have. So what's the difference between a tangible asset and intangible? Tangible would be something physical. So that would be the home, the land, other real estate, vehicles, cars, motorcycles, boats, things like that, as well as things in the home. So all your personal possessions. Some of that might be high value individual items like collectibles, coin, art, antiques, trading cards, things like that, as well as just your regular furniture, all the physical belongings. Okay. Understand that the terms of your will dictate how physical belongings are split up. So say you had 3 adult children and you name each beneficiary a third, a third, a third. Okay. Recognize when you allocate some of your physical belongings that there might be potential for them to have to sell items to be able to split it up or internal delegation. So you have very specific gifts that would be important, i.e. a family heirloom ring to a daughter, for instance. Then it would be important potentially to consider naming, I would like my daughter to receive such and such ring, as opposed to just being equally split in this such an example. The intangible assets are different. So they're not physical. These are now assets that can't touch or hold, but things like ownership in a business, bank accounts, health savings accounts, the financial assets that may have different rules preceding them that may be governed. For instance, retirement plans like IRAs or 401ks and life insurance policies are not going to be dictated by the terms of the will. They are going to be dictated by the terms of their beneficiary designations. So your will might say one thing. If your life insurance policy says another beneficiary, the life insurance policy beneficiary designations win out. So it's important that both of these be looked at to align with your wishes. So we look at all the assets, intangible and intangible. You kind of estimate the value and then understand how much money are we talking about. For the vast majority of our clients, we're dealing with assets well below the federal estate tax. which currently as of right now is a little bit over 15 million. So most of our clients are somewhere between 2 to 7 million in net worth, in which case we don't have to worry about some of the federal estate tax issues. If you are in a state that has a lower threshold, then you may need some more specific planning. So I'm looking at you, Washington, Oregon, Massachusetts clients. There's a few others, just for example. So when you consider the value of your state, now you can account for your family. So if you're a widow and you're trying to figure out what's next, you might be thinking, well, I already have life insurance. Do I need that? Well, maybe, maybe not. Like many questions in financial planning, it definitely depends. If you have enough assets from what you already collect to care for all of the income needs of you and say your children, if something were to happen to you, then additional life insurance may not be necessary. We talked about how guardianship kind of plays into this role. We want to make sure that if you're considering the financial situation of the guardian, that there would be enough assets in the estate, in the trust, to provide for them. For example, providing for additional income sources to add on to a current house, to move to a different house, be able to accommodate your children, to be able to pay for the education needs that and medical needs that your children would be a part of that. So all this goes into the idea of accounting for your family, and then the idea of not documenting your wishes. So again, if you don't document who you want to step in this role, a judge could name the guardians rather than you having them listed out there. Don't assume that certain family members or people that you would name in those roles will be there, or that they will share your child rearing ideas and goals. This is where it's important to consider that and ideally have conversations with these people as a part of naming them. We've talked about the directives, but just in more specificity, a medical care directive, that living will, spells out your wishes for medical care if you're unable to make decisions for yourself. You can also give that trusted person that medical power of attorney for your health care that gives that person the authority to make decisions if you can't. The durable financial power of attorney allows someone else to manage your financial affairs if you're medically unable to do so. This designated agent can act on your behalf in legal and financial situations when you cannot. Many of my Gold Star clients are very familiar with this from working on the deployment side of life and having to pay bills while their service members out of sea. So it's the same idea here, except durable just means it exists when you're incapacitated as well. Limited power of attorney, by contrast, would be someone saying, I have power of attorney over this specific item, for instance, a car, or being able to sign closing documents or sale of a specific stock. We referenced trust a couple of different times throughout this, so let's just step back and think about when and how this might be appropriate. A trust in this case, we're typically talking about a living revocable trust. What that means that you, as the person setting up the trust, as long as you're alive, it's considered set in sand. You can come back, you can change it, you can edit it, as opposed to an irrevocable trust that becomes unchangeable, things that is set in stone for the most part. So with a living revocable trust, as long as you are alive, you can designate, change things up. But if you were to become ill or incapacitated or die, then the selected successor trustee steps up and takes over. Meanwhile, upon your death, then the trust assets, everything that's already owned in it, for instance, we would transfer real estate or other assets into the trust. They will bypass probate, saving your estate potentially thousands of dollars, being more private, and just generally smoother process in many cases. The final arrangements are also going to be part of your estate documents, typically as a part of your will, dictating would you like to be buried, would you like to be cremated, what are the wishes that you would have related to that. Reviewing your beneficiaries. I referenced this, but again, just focusing on it again. Your retirement and insurance accounts are different than what your will says, okay? Unless you specifically align them, the retirement and insurance account beneficiary designations will overrule anything that the will states. So making sure that the right people are named in the right ways to be able to do that. And in the case of naming contingent beneficiaries versus just a primary, that way if the primary beneficiary is unable to claim for whatever reason or has predeceased you, that it still flows through. We referenced the estate planning considerations at the state tax level, so that's important. And all this goes to the idea of sometimes professional help can be of support. We referenced special needs earlier. So within our practice, we actually help clients draft estate planning documents with the assistance of an outside scrivener service called Encore Estate Plans. So over the past several years, we've done over 36 estate plans, helping clients put their own wishes down, document it, get it updated, funded, and again, part of that peace of mind. But typically, again, for large or complex estates or special needs or things like that, we're going to always refer that out to a specific estate attorney. Now, just because you've got an estate plan set does not mean that you're done. In this case, life changes, life evolves, and sometimes that means your estate plan may also need to do that. So, in our firm, we typically review estate plans, if nothing else changed, every odd numbered summer year. So, last year in 2025, we did it for all clients. We'll do it again in 2027 proactively. However, other things can change. For instance, you move to a different state, you remarry, a divorce happens, birth of a child, loss of a loved one. Some of the people that you've named in the successor orders for financial or guardian powers, for instance, their lives might have changed. Maybe your wishes don't align. So revisiting it regularly can help it align. I cannot tell you the number of problems that we have seen from clients in other scenarios with estate plans that are 5, 10, 15, 20 plus years old and just never gone back to look at. It should evolve as your life evolves as well. Let's talk about storing your documents as we come towards the end here. So once you have your documents, you want to have your physical, the wet signed ones that you have, stored in a safe place, ideally like a fireproof safe or something that would be access to, but not, say, destroyed in a natural disaster event. You want the important people, so that successor, executor, those important people know where they could come get it, right? We do not want to keep it a secret here. So generally, you don't want to put it into something like a safe deposit box in case you actually still have one of those. Not too many of them out there, because those can be locked down, much harder to get access to, which creates a loop where you have to prove that you're the executor, but you can't prove that you're executor until you have the documents, but they're locked up. So having a better way to do that. Lastly, then, also having digital copies made and then stored with important people such as your estate attorney, financial advisor, tax professional, and other key people who can step in. All right, so we've covered a lot of ground today. There's a lot to estate planning, but I can promise you having a well-ordered estate plan, having made these decisions the best that you can today, knowing that life may change in the future, can give you confidence so that you can go from lack of peace of mind to having more control. If we could help with this part of estate planning, it would be our privilege to do so. In fact, a complementary estate plan, so that's drafting will, trust, medical power of attorney, financial power of attorney, all the things that we talked about today, is complementary for clients who work with us on an ongoing basis, and we include that as a part of our service. So if there's something that interests you as a part of financial planning, we would love to be a help to you. Feel free to go to our website, wisestewardshipfp.com, where you can book an initial consultation, and we would love to help you. Until next time, keep working, keep planning, and take this one step at a time on your grief journey.
Thank you for listening to this episode of Widow Life and Money. Want even more resources and information on how to make better financial decisions along your grief journey? Go to www.wisestewardshipfp.com/WLM/EP12, where you'll find the specific resources from this episode. While there, you can also schedule a free, no obligation conversation with Daniel. If you enjoy the content, please leave us a review and share with other widows who would also benefit from this information. This podcast is for informational purposes only and should not be used as the basis for legal, tax, or investing advice. Daniel Kopp is the founder of Wise Stewardship Financial Planning, LLC, a registered investment advisory firm in the state of Florida. Opinions and information expressed are as of the date of recording and are subject to change. The views and opinions of guests on this program are not necessarily those of Wise Stewardship Financial Planning. Daniel and Wise Stewardship Financial Planning are not affiliated with guests or their business affiliates unless otherwise stated.